New immigration rules for refugee settlement. In today's video update, we will talk about the new immigration rules for refugee settlement. Migrants who are in the UK on a protection route, that is those who have been allowed refugee status or humanitarian protection, and their family members, have their own precise route to settlement, also called indefinite leave to remain in the UK. The laws on settlement for these individuals are administered by the new Appendix Settlement Protection, which from the 6th of October 2021 changed paragraph 339 RT of the immigration rules.
UK
single global
immigration system.
Those on protection routes do not succeed for settlement on their own and need to make an application after spending 5 years in the UK. Now let's discuss when to apply for refugee settlement. Migrants in the protection route are entitled for settlement after completing 5 years in the UK with permission to reside on the route. On the other hand, individuals need to apply before the expiry of their 5-year grant of permission. The expiry date will be mentioned on the biometric residence permit granted to individuals in the protection route. Please keep in mind that if an individual does not make an application for settlement before this grant of leave expires, they will turn into an overstayer in the UK. While it is essential for applications to be made on time, they should not be made too early. The UK Home Office guidance recommends that applications should be made in the last month of a migrant's permission to stay. Applications made significantly earlier than this is described in the guidance, as more than 3 months remaining on the 5-year grant of leave, will be rejected, unless there are extraordinary situations. Now let's tell you which dependents can apply for settlement. Partners of refugee. Please keep in mind that, for the dependent of a main applicant to be entitled for settlement as a partner, they need to be granted leave in line with the main claimant, who has approved refugee status or humanitarian protection, according to the definition of dependents mentioned in paragraph 349 of the UK immigration rules. A partner who was not permitted protection leave, corresponding to the main applicant, cannot apply for settlement via this route. The bond between the applicant and their partner need to be authentic and existing, and the applicant and partner must plan to carry on to reside together as partners in the UK. Children of refugee. Please keep in mind that, for the dependent of a main applicant to be entitled for settlement as a child, they need to be either granted leave, together with the main applicant, who has approved refugee status or humanitarian protection, or they must have been born in the UK, while the main applicant had authorization to stay in the protection route. Furthermore, if an application is not made on behalf of a child born in the UK, until after the main applicant is authorized settlement in the protection route, the UK Home Office's guidance states that this should not be held against the applicant. Lastly, let's tell you about family reunion. Partners and children who are authorized leave under the family reunion policy, having fulfilled the obligations of paragraphs 352A to 352G of the immigration rules, are entitled to apply under Appendix Settlement Protection. This is the end of today's video update. We hope you found this video update useful. Don't forget to press the subscribe button and hit the bell icon so you don't miss any updates. Thanks for watching.